Ladies and gentlemen, 15-second warning order. Ladies and gentlemen, as we start our last presentation, I know when General Lepper is finished, people are going to be hightailing in different directions. So what I wanted to do is to allow you to see and perhaps congratulate our team of volunteers. And they're from different schools. They're mainly Duke Law, but from different schools. They're undergrads, and believe me, you cannot put on a conference without a team like this. And they're just wonderful young people that I'm so proud to be associated with. Hope you will join me in giving. But there's someone else. Stephanie, please come up here. I can't begin to tell you how important Stephanie is to this conference. She has taken on a burden that is unbelievable, and she's taken it off of me. I was able to concentrate on trying to organize the speakers and so forth. What this woman has done and what she has contributed to the educational opportunity that we all had at this conference is really incalculable. I can't really thank you enough, Stephanie. You've changed my world for positive, and I really, really appreciate it. And then one last person I want to recognize is Mrs. Dunlap, who had to put up with me for my stress modes, even more than what Stephanie had to put up with. So thank you very much, Joy. Okay, folks, back to your post. Steve, you'll have to speak for 2 more minutes here because Steve Lepper, Major General Steve Lepper, USAF, and today I can say retired, I guess, sort of, kind of. And Steve and I have go back 30 years, and Steve just is in the process of transitioning to a new job with ABA, but he had my old job in the Air Force, and I've got to tell you about Steve. Not only did he go to the Air Force Academy and he went to Duke Law, but over the years, the thing about Steve that I've just so admired about him, he is not only a super smart guy, and he is LLM, I think, from GW or Georgetown. Oops. I don't like to say Georgetown too much down here. But he's been a friend and a mentor, and most importantly to me, a man of integrity. Steve has been in some of the toughest jobs, high-stress jobs, including the last couple of years, where he has maintained his integrity when other people would have been compromised, I can assure you. And they would have talked themselves into some sort of rationale why it wasn't really a compromise. And that's why I'm so pleased that he was able to fit it into his schedule. He was on duty yesterday in the Pentagon, and he drove down here last night to be with us this afternoon, or still this morning. And without further ado, Steve, please.
Well, I want to start, first of all, by thanking you, Charlie, for inviting me here. It has taken 4 years, but it really is great to be back. The confusion about my status is probably due to the fact that yesterday was my last day in office as the Deputy Judge Advocate General. And for those of you who understand how we're structured, both the Judge Advocate General and Deputy are statutory positions, and my leaving means that my successor can now take over. The problem is we don't have anybody confirmed to do that. Going back to some of the previous conversations about the function of our bureaucracy in Congress. So anyway, we're continuing to limp along in the Air Force with temporary help, but we've got some really excellent people, some of whom are here in the audience, helping us get through this transition in leadership. And with folks like that, it really makes leadership very easy. It really is an honor to be back here. I've been trying to figure out exactly where I am in this building because nothing looks familiar. It's been 30 years since I've been here. In fact, my 30th reunion is next month in April, and plan to come back for that. One of my biggest regrets, though, as I mentioned to Judge Everett's son last night, was not having come to an earlier reunion, which would have preceded Judge Everett's death by a couple of weeks. And those are opportunities that you have, and the work gets in the way, and you don't take, and then finally you regret not taking them. And so, again, it's great to be back here with all the memories that coming back here has for me. One of which, speaking of Judge Everett, who is the founder of this organization, the founder of this conference, and who passed the torch to Judge Silliman and now to Professor Dunlap, was, as a professor of mine, Judge Everett was at the time the chief judge of the then Court of Military Appeals in Washington. He spent most of his week in Washington, but he traveled back here on Wednesday evenings, and Thursday mornings and taught classes, one of which was a military justice course. And at the time, Duke was filled with military officers, military students, because at the time we had a number of funded legal education program students who viewed Duke as a great place to come to learn the law, and very military friendly place to come to school. And so what Judge Everett did was he had the course on military law over at his mother's apartment. He and his wife lived next door, and his mother lived there in an apartment just down the hill from the school. She was in her 90s, and she participated in our discussions, fed us Coke and Oreo cookies, sugar and caffeine. That's right, sugar and caffeine to keep us awake. But Duke will always hold a great place in my heart because of the personal approach that it takes to teaching law. And I want to thank all of you, especially those of you who are graduates within the last 30 years, as well as you students out there, and of course the faculty, for enhancing the value of the Duke degree over the years that I've been honored to put it on my wall. This is the ethics part of the course. I fortunately am a North Carolina lawyer, and hopefully will be able to take advantage of the fact that I'm actually giving this ethics block, because I now need to start logging my CLE and paying my dues. So what I'd like to do today is just talk a little bit about the role of professional responsibility. The other way. All right. The role of professional responsibility, and what we as military lawyers in particular, government lawyers in general, do for our respective clients. And a lot of this is probably going to be Professional Responsibility 101, but it's with a twist. It's Professional Responsibility 101 applied to the kinds of things that I never knew I would have to do when I was sitting here as a student. And it comes not necessarily from a foundation of being an expert in professional responsibility. So one of the caveats I want to give you right up front is that in addition to the disclaimer there, which I guess I still have to include because I'm still on active duty till 1 April, which you no longer have to do, I guess. I wasn't so good about it when I want to also give you the caveat that I'm not an expert, and I would appreciate, as the issues arise and as you have maybe different perspectives on some of the things that I'm going to be talking about, pitch into the discussion. I want this to be as interactive as possible. Ask questions when they arise, and I'll try to answer. And if I can't, I know there are a lot of other former JAGs, current JAGs, other government agency attorneys in the audience who I'm sure will come to my rescue. As Mr. Preston said last night in his remarks, or at least in one of the questions he responded to, there are actually multiple ways of looking at ethics. You know, there's the ethics writ large, the sort of philosophy ethics, the ethics that underpin our discussion in the public about the use of remotely piloted vehicles, among many other things. There are the ethics that bind us as government employees. The document that Mr. Preston referenced last night, the Joint Ethics Reg, is a regulation that is promulgated by the Office of Government Ethics and talks about what kinds of honoraria we can accept or airline tickets we can accept to come to functions like these. The third piece is the professional responsibility piece, at least for us lawyers. And it is basically modeled, our professional responsibility standards are modeled after the ABA model rules of professional responsibility. Not all agencies in the federal government have their own tailored rules, but the Air Force does. And so what I'm going to do here today is talk in terms of the Air Force rules that I have been subject to and dealing with over the last 30 years, in the hope of at least providing an example of the kinds of ways in which we as a government agency have tailored those model rules or those state rules that we are bound to by being licensed in particular states, and adapted them to the kinds of functions that don't normally exist outside the government, particularly in the national security law area. One of the, just by way of introduction, one of the things that has been discussed here, I noticed over the last couple days, is relevant to this because it basically is sort of a redefinition of the role of a lawyer. When I graduated from law school, I was going to be a judge advocate. I knew I was going to be a judge advocate, and so I focused on what my role would be as a judge advocate, as an advisor, as a counselor to commanders, to the Air Force, to individual clients that I may have come for legal advice. I never expected to be an individual actor in the process which we now know as lawfare. When I thought of operators when I was in law school, I thought of pilots. My brother was an F-16 pilot at the time. I knew exactly what he did. He flew airplanes, he shot guns, he dropped bombs. He was an operator. I know what folks who sit behind computer terminals do today in the area of cyber warfare. But I never expected as a lawyer to actually be an independent operator in the area of lawfare. And so a lot of the rules I learned, and in fact a lot of the rules that currently exist in our Air Force rules of professional responsibility are not necessarily a good fit in what we are expected to do as independent actors in our military. And so as I go through these rules, I'll try to talk a little bit about how the rules currently are written and about how they sometimes don't provide us the kinds of answers we need in delicate situations, some of which we have seen in the newspapers. And I'll sort of wrap a lot of this stuff in some war stories out of the front pages of the news. So, again, Professional Responsibility 101. The first question, very basic question, is who are the Air Force lawyers' clients? Again, most lawyers understand who their clients are. If they are if they're lawyers in private practice, it's usually individuals. If they're general counsel, it's usually the corporation, perhaps even some of the individuals in the corporation. But in the military, it's a little bit different. And so we teach all of this in our basic judge advocate course. I'm sure the Army and the Navy do likewise. And after we teach it, we sort of put it in the back of our minds and don't think about it much anymore as we go through our careers. The times when we start thinking about it are the times when conflicts arise. And in fact, most of the rules that we now have have been developed, at least in application, as a result of the conflicts that we have faced in how we operate as lawyers and who we advise as lawyers. So the conflicts really define the rules. Oh, let me go back one. And then I'll talk a little bit about what duties, once you define who your client is, what do you owe your client as an attorney? And last but not least, I'll talk a little bit about what roles lawyers play. We talked about the independent operator role, but there are lots of other roles that we perform, many of which have moved us to the point where we are independent operators now. So I'll talk a little bit about that. So, to start, who are the Air Force lawyers' clients? Our Air Force Rules of Professional Responsibility basically provide a definition that has about 5 points in it. I'll read the definition and I'll point out the 5 points. The Rule 1.13a says the Air Force is your client. And it says, except when authorized to represent an individual client or the government of the United States, an Air Force judge advocate or other Air Force lawyer represents the Department of the Air Force, acting through its authorized officials. Now, there's a lot packed into that, and let me unpack it a little bit, going in reverse order. First of all, the Department of the Air Force is our client. It's our government agency. It's not the whole federal government. It's not an individual commander or client. It's the Department of the Air Force. The only time when we can represent the federal government or an individual client is if we are authorized to do so. That authority may derive from statute, and I'll talk about one situation in which that is the case. It may derive from the authority of the Judge Advocate General to allow us to represent individual clients or clients other than the Air Force. And so there has to be a specific conscious decision whenever we represent anyone other than the Department of the Air Force for us to be able to provide that representation. The last words in there are through its authorized officials. And that is where a lot of the confusion usually arises. We all work for commanders, and our job as judge advocates is to advise commanders in execution of their responsibility to execute the mission. So our job is mission-oriented, it's focused on the commander, and a relationship typically develops, usually a close relationship, between a commander and his JAG. But as you'll see in a few minutes, authorized officials may sometimes be elusive. It may be where you have to define authority. You may have to determine whether or not the authorized official is acting within the scope of authority in order to determine whether or not you can still advise the authorized official. We'll talk a little bit more about that in a minute. So, who are the authorized officials? Typically commanders, and the presumption is that when they're acting within their authority, they are the ones who represent the Department of the Air Force. Now, there are also other opportunities for us to represent other clients. I've listed a few of them on here. Area Defense Council. The Area Defense Council program is defined by the Uniform Code of Military Justice, which is a federal statute. So that is the authority that we have to represent individual members of the military. And I'll talk a little bit more about that in a few minutes. Legal assistance. 10 U.S. Code 1044 is a statute that allows judge advocates to advise individual clients. And they need not be military clients. They can be non-DOD clients, family members, for example, are folks who we can provide legal assistance to. And so that is statutorily provided. One of the areas of controversy recently that you may have seen in the newspapers, and I know our judge advocates here in the audience certainly are aware of the controversy, is the whole idea of providing a victim of sexual assault with a lawyer. When we, as an Air Force, decided that we were going to establish what we're calling a Special Victims Counsel program, whereby we provide a victim of sexual assault an attorney to help him or her deal with some of the rights that a victim has in the military justice process, it was met with a lot of skepticism, opposition, and it was also a concern that we were giving a lawyer to a victim and thereby, in some respects, creating a civil system out of a military justice system. Providing a lawyer to the victim and, of course, a defense counsel to the accused creates a situation where At the very least, you've got two parties whose positions are opposed to each other in a more civil-like context, appearing before a military judge who's there to determine guilt or innocence, or a jury who's there to decide guilt or innocence. At the very worst, it creates a situation where you have a lawyer for the victim teamed with a prosecutor in a 2-against-1 situation against the accused. So that whole perception created a lot of concern among folks who really understood military justice. It was such a drastic change to the way that we did military justice that it counseled great care in the way we approach this. I listed a couple of things here under Special Victims Counsel Program. MRE 514 provides a relationship between a victim and a victim advocate already in the Military Rules of Evidence. What that particular privilege provides is that a victim of sexual assault can go to a victim advocate, someone who is designated as a person who's there to provide support to a victim, and anything that is said in the conversation between the two can't be introduced into a military criminal trial. Now, that in and of itself was not sufficient to provide us justification for providing a lawyer to the victim. Again, going back to the authority issue, what authorized us to give the victim a lawyer? Well, we stretched the whole idea of legal assistance to conform to the idea that the victim really is getting legal assistance from an Air Force attorney, and therefore we can use 1044 as a basis for providing a victim a lawyer. We asked the DoD General Counsel for an opinion as the Chief Legal Officer of the Department of Defense, and Jay Johnson said, yes, I agree, go forth and do good things. And so that was the genesis of the Special Victims Counsel Program in the Air Force, and since then, the NDAA, National Defense Authorization Act, has provided specific statutory authority for the Special Victims Counsel Program. So, U.S. v. Kastenberg was a case. Kastenberg was a military judge who said, I don't like any of this. I don't think we should have victim or lawyers for victims. And I'm not going to allow the Special Victims Counsel to represent the victim, basically. That case was overturned by the Court of Appeals for the Armed Forces. And so now, additional justification for allowing, or at least not preventing, a lawyer from representing a client in those contexts. So now that once you figure out who your client is, what are the duties that you owe the client? Well, if it's an individual client, an accused, a victim, someone who is seeking legal assistance from you in a personal civil legal matter, you owe the client what any lawyer owes a client, and that's loyalty and confidentiality. And it's in both of those areas where the conflicts have arisen that have driven us to conform, adapt our rules to the particular circumstances that we confront as military lawyers. In the ADC and Special Victims Counsel context, what it caused us to do early on in the history of the Area Defense Counsel program is to separate the defense counsel from the lawyer who provides advice to the convening authority. Before 1974, the Area Defense Counsel was actually part of the legal office that supported the commander, who was empowered to make military justice decisions. On one particular day, the lawyer may be prosecuting an airman. On another day, the lawyer may have been defending an airman. And the perception that was created as a result of that lawyer working for the judge advocate who was advising the person who made the military justice decisions caused us to be concerned about the loyalty of the lawyer to the airman, at least the perception of where that judge advocate's loyalties lay. And so, as a result, in 74, we pulled the Area Defense Counsel out of the legal office and created an independent chain of command for the lawyer in order to enhance the perception, at the very least, that the ADC worked for the airman who was being subject to military justice. The same thing is true now for our Victims Counsel program. What we did when we started the Victims Counsel program was we took JAGs out of the legal office. But when we did that, we made it very clear that those lawyers no longer work for the convening authority. They work for the victim. We have since institutionalized the program and created a permanent cadre, permanent meaning a 2 or 3 year assignment in the military, of lawyers who represent victims independently. Their chain of command is basically the same chain of command as the Area Defense Council. They both report to a commander in Washington. Far enough removed, we believe, that it doesn't cause a problem with the loyalty question. The legal assistance piece of this is that what we do is we advise non-DoD personnel, and we could not do that without 1044. Our loyalty is to the client, and in some cases, especially in cases where you've got a client, let's say a domestic dispute. You've got two people who are married or related who both come into the legal office. Those sorts of issues have caused us lots of problems over the years. The services have approached those concerns differently in many cases. Where there are Army bases next to Air Force bases or Navy bases, often what the legal office will do is if there's a domestic dispute, they'll send the husband in one office and the wife to another, just to be able to create a perception that there is an independent advice given to each of those people and that they're not all working for the same senior lawyer. There are also some exceptions to confidentiality, not loyalty, but confidentiality. We'll talk a little bit about the loyalty piece here in a minute. But when it comes to confidentiality, that too has caused us lots of problems over the years in the Air Force. If the Air Force is our client and we are authorized to represent individuals, what if the Air Force's interests diverge from the individuals? Well, our canons of ethics as lawyers require us to keep the confidentiality of whoever we decide our client is. And if it's in an individual context, especially with respect to an individual accused or a victim or a legal assistance client, the only exception really is to prevent imminent death and substantial bodily harm, just as it is in our state bar codes of professional responsibility. No difference. The difference comes, and the way in which we've tailored this for the national security environment, is that there's an additional exception, at least in the Air Force rules, that allows a lawyer to divulge confidences in order to prevent substantial impairment of national security. Okay? So it's a pretty important exception to something that every American believes is a sacred obligation of a lawyer to his or her client. Let's shift gears to the institutional client, the Air Force, or a government agency if authorized to represent the government agency. Same duties, same obligations that a lawyer has to the institution as he or she has to an individual client, loyalty and confidentiality. The big problem here is, to whom do you owe that loyalty and confidentiality? Is it the authorized official who is acting within the scope of authority that you have that personal relationship with? Or is it the institution? In most cases, fortunately, it's the same thing. In most cases, the commander, we'll use as the example, the commander, the individual, the authorized official, has the same interests as the Air Force. And if that's not true, that's what we're there to provide, is advice on how to align the commander's actions with those that the Air Force expects. But sometimes those interests diverge. And when they do, what we as lawyers are obligated to inform our commanders is that, boss, we represent the Air Force. And what you're about to do actually is inconsistent with what the Air Force policy is on this issue, and so I can't represent you. Okay? I can tell you what the Air Force position is, I can tell you what the law is, I can tell you what the policy is, but if you decide that you're not going to go in that direction and you are held accountable for it, I can't represent you. Now, there are a couple of specific instances where that duty to report an authorized official's unlawful act or act contrary to policy provides an affirmative obligation to report. And one of those is in the law of war context. Mr. Preston said last night that one of our points of pride in the U.S. military is that we, regardless of what the enemy does, we follow the laws of war. And one of the ways that we have institutionalized that is that we have an obligation, every single person in uniform has an obligation, including lawyers, to report violations of the law of war. So it's an affirmative obligation that we typically believe fits within the national security exception to confidentiality. Again, going back to the whole lawfare argument, the reason that law is so important in warfare is because situations like Abu Ghraib have demonstrated that we can suffer a strategic defeat by violating the law just as easily as we can suffer a strategic defeat by being actually defeated on the battlefield. And so the national security exception would apply to that obligation to report law of war violations. There is also an obligation, or at least an ability, for judge advocates to report these sorts of situations through their functional chain, up through to their supervisory judge advocates. And it's called Article 6 of the UCMJ, 10 U.S.C. 806. It is the authority that the Judge Advocates General of each of the services rely upon to lead their JAG Corps. And as part of that connection between the Judge Advocate General and all the JAGs and other legal professionals that fall within the respective JAG Corps of the services is an obligation that there is unfettered communication. Unfettered meaning no one can interfere with it. And so it's a little like being able to go to your partner in a law firm and pose a question that you don't know the answer to. The same confidentiality applies when lawyers talk to each other. But what Article 6 also gives the ability of the more senior lawyers to do is, in certain circumstances, actually go to the more senior commander and get the more senior commander to perhaps take responsibility or authority over the issue that the authorized official isn't handling properly. The context in which we see that most often is in the military justice context, where the lawyer may not agree with what the commander intends to do in a particular military justice case. In that situation, the judge advocate can go to the next senior judge advocate who works for the next senior commander and have that next senior commander take responsibility for the case. You know, on its face, it violates the idea that there is confidential communication. But it is part of the exception where the Air Force's interests may not be aligned with the individual authorized officials. So, we have in the Air Force a saying, JAGs advise and commanders decide. What I've just talked about kind of adds a little postscript to that, unless the commanders get it wrong. Now, one of the big debates going on right now surrounds sexual assault. And many of you have probably been following, I know those of you in uniform have been following the whole evolution of the Gillibrand bill that is currently working its way through the Senate. Now, Senator Gillibrand wants to take all military justice authority away from commanders and give it to JAGs. My argument, our argument, as the military, as an institution, has been you shouldn't do that. You shouldn't do that. Our primary argument has been because Commanders have to be responsible for good order and discipline, and unless you give them the military justice tool, you're robbing them of their ability to get the mission accomplished. You're robbing them of their ability to train, organize, train, and equip a disciplined force that can actually accomplish the mission. What I've just talked about is an additional argument, and it really is one where if Senator Gillibrand really understood it, she'd be less concerned about the role of commanders in military justice. Because there is that safety net there of judge advocates who can diffuse errors in judgment of commanders. And we'll talk a little bit about that in a couple of contexts here in just a minute to show you where those conflicts and that friction arises. What are the roles of a military attorney? We're there to provide both advice and counsel. And it's not just the law. You know, one of the things that I didn't realize when I graduated from law school is that lawyers do a lot more than just advise on the law. There's a lot of stuff you need to know that's not found in any law book anywhere. There are policies, there are practices, there's culture. The culture that has prevented us from making the Uniform Code of Military Justice truly uniform. The culture that results in the different application of policy based upon the environment in which you operate. And so we as judge advocates in this role, this professional responsibility role as advisors and counselors, are not limited just to legal matters. We have an obligation to advise on anything else that may have an impact, good or bad, legal or illegal, on the organization. And in performing that role, we have certain obligations, obviously candor and fairness. One of the things that commanders appreciate most about lawyers, and they really do appreciate lawyers, even though they joke about not appreciating us, is that they know that we will tell them what we think. We're obligated to do that. Whether you're a civilian lawyer or a military lawyer or a civil service attorney, you are professionally obligated to provide candid and fair advice to your client, whoever that client is. And over the last number of years, probably about the last 10 to 20 years, the environment in which we provide that advice has become much, much larger. It used to be, especially when I first became a JAG 30 years ago, that my job was limited to the things that the commander needed to be concerned about in the legal realm. Claims filed against the government, contracts, employment, legal issues, military justice. Those were all the responsibility of the JAG, and we didn't venture far beyond that. Today, there are lawyers involved in providing advice to authorized officials in just about everything they do and in any environment they happen to be operating in, particularly the media. A number of years ago, I had the opportunity as a colonel to serve as the chief crisis communicator for the Air Force. And in that role, I led a group of 12 non-lawyers, 12 people who came from multiple disciplines. I had a pilot, I had someone who had legislative experience over on the Hill, I had a personnel officer, I had a civil engineer. You name it, I had someone who understood that particular discipline in the Air Force. And as a lawyer, my job was to provide that candid, fair advice, not just on legal issues, but all the issues facing the Air Force to the Chief and the Secretary of the Air Force. And the Secretary and the Chief of the Air Force wanted a lawyer in charge of that organization because they knew that we had this obligation to be thorough, candid, and fair in the advice that we provided. We also were connected through that stovepipe, that chain of communication I just talked about, to other JAGs in the field. So the media has become an area of responsibility for us that didn't exist as recently as 10 years ago. And one of the things that we have found as we have enhanced our media practice is that the lawyer typically ends up being the mouthpiece for the Air Force. We learned that lesson the hard way in the Kelly Flynn case. Many of you probably don't remember Kelly Flynn, but she was a young Air Force Academy graduate, pilot, B-52 pilot, who decided that she would have an extramarital affair with the husband of an enlisted person. And in the process of holding her accountable for that violation of the Uniform Code of Military Justice, she hired a lawyer, a retired Air Force JAG, to help defend her in the court-martial she was facing. That lawyer, Frank Spinner, went to the press and made it a huge spectacle in the press. Ultimately, the spectacle he created and the support he attracted by recharacterizing the situation as one where the Air Force was trying to beat up on this poor lieutenant who simply fell in love with this guy at Minot, basically tied the hands of the secretary so that the Secretary of the Air Force could no longer hold that person accountable under the UCMJ and instead had to simply allow her to resign her commission. That case was the reason why the Secretary-in-Chief of the Air Force decided to put together this strategic communication team headed up by a lawyer. He wanted there to be parity in the weaponry that was being used. And so now we have parity, not just with that strategic communication apparatus, but now with each and every lawyer in the Air Force. A couple of examples. Recently, you're probably aware that there were two senior commanders in the Air Force who were pilloried in the press for decisions they made to overrule sexual assault convictions. Lieutenant General Craig Franklin, who is the commander of 3rd Air Force in Europe, and Lieutenant General Sue Helms, who is the commander of 14th Air Force at Vandenberg. Some of you may have heard Sue Helms' name before. She holds the record for the amount of time in space. National hero, astronaut. In both of those cases, they, as the General Court-Martial Convening Authority under Article 60 of the UCMJ, had the authority, but even more importantly, the duty to consider whether the jury got it right when they convicted two accused of sexual assault. And in execution of that duty, that responsibility, that authority, they decided that there wasn't proof beyond reasonable doubt sufficient to convict, and they overturned the convictions. That was the final word in the case. No appeal. That was it. The way this was played out in the press was that a travesty of justice had occurred, that two sexual assaulters had been let go by commanders who didn't know what they were doing. They did know what they were doing. They got advice from their lawyer. They went through the record of trial, read every word of it. They weren't in the proceedings. They did consider matters outside the record, but that was their responsibility. That's what the law allowed them to do. And so as they became targets of criticism from the Hill, from the press, from the public, their lawyers, or at least two lawyers, one lawyer in each case, stood up and started engaging with the media. In one case, the Helms case, the lawyer stood up and started defending his boss to the point where he wrote a law review article, op-eds in the Wall Street Journal, and basically came to General Helms' defense, saying all the things that I just described, that she had a duty and responsibility to exercise her best judgment, and she did that. Was that consistent with the obligation that he had as a lawyer to represent the Air Force? Good question. And it really comes down to the question, again, going back to the conflict issue, were the interests of the Air Force congruent with the interests of General Helms at that point? Did General Helms, by making that decision, put herself in a position where the Air Force, which also received a lot of bad press, sort of distanced itself from her? I think you can probably say that that happened. And since that happened, did that have any impact on the professional obligation of the lawyer to also distance himself because he didn't have authority to represent her in her personal capacity? It's a question that I can't answer, but it's a question that is squarely within the rules of professional responsibility. When at some point the interests of the organization and the individual diverge, does the lawyer now have to abandon the person that he was providing advice to and not defend that person? Steve Lepper, my personal opinion, I think the lawyer did the right thing. I think the lawyer did the right thing by pointing out to everyone that she had this duty, this responsibility, and frankly, that if people didn't like it, they ought to change the law, not criticize her. The other case, the Franklin case, the prosecutor didn't like the fact that that General Franklin overturned the decision. And the prosecutor went to the press. And in his personal capacity, criticized the general's decision. Was that consistent with the rules of professional responsibility? Again, the Air Force was distancing itself from General Franklin as well. So was it legitimate now for the prosecutor who represented the government's interests at that trial to now also become more vocal in criticizing the commander for doing what he thought was right? Tough question. My personal opinion, I don't think he should have done it. Again, the whole idea is the law authorized it, the law required it. And for us to now criticize the commander simply because our position seems to have diverged as an organization, I don't think is being fair to either the Air Force or to the individual. So let me move on. I think we're on good pace here. All right. Okay, so the first example really is what I've just been talking about, but what I do is I contrast that with another case that lawyers played a role in, and that was the case of General Moseley, our former Chief of Staff of the Air Force. Now, in the two cases, Helms and Franklin, we had two lawyers taking opposite views of a commander's exercise of his and her legitimate authority. In the Moseley case, the Judge Advocate General of the Air Force advised the Chief of Staff, who presumably is an authorized official, not to do a certain thing with respect to a contract that he wanted to give to a friend. The Judge Advocate General advised the Chief of Staff, you don't want to do this. This does not look good. It could be perceived as nepotism, self-dealing. It doesn't conform with the competition requirements under federal law for government contracts. You cannot sole source this contract to some guy you were introduced to by a fellow four-star general. At the end of the day, the General Moseley decided not to listen to his lawyer. What is the lawyer's obligation under those circumstances when the Inspector General comes knocking at his door asking what advice he gave to the general? The Judge Advocate General handed over emails that reflected the conversation that he had with General Moseley. Was there an expectation on General Moseley's part that there was confidentiality between him and his Judge Advocate General, a person that they had been working for throughout their entire tenure in their respective positions? Probably. Was it appropriate under the professional responsibility rules for the Judge Advocate General to disgorge those communications that he had with the person who presumably was his client? I say absolutely yes. And it's a lesson, unfortunately, that General Moseley learned too late, was one of the reasons he was fired. But it is one that other lawyers and their clients need to take from that episode, part of the rules of professional responsibility. Colonel Romano, the conflict between U.S. and international law. I mentioned that we have an obligation to look at more than just our law. We have an obligation when we're operating overseas to also consider what international law provides, especially when it impacts our ability to do our mission in that foreign country. In the Romano case, then Lieutenant Colonel Joe Romano was the security forces commander at Aviano Air Base in Italy when a suspected terrorist was apprehended and brought to Aviano to be transported by a U.S. government aircraft out of Italy. Romano was presumably the guy in charge of those security forces who cuffed him, took him to the plane, and got him out of Italy. Italy didn't take kindly to that. Italy considered it to be a violation of their sovereignty. Italy considered it to be an unlawful rendition because it wasn't done with their permission. And so what Italy decided to do was prosecute Colonel Romano. By then, Colonel Romano had left Italy, and so they did it in absentia, which their law allows them to do. Under most circumstances, when we're faced with an individual, whether it's a military member or someone affiliated with the U.S. forces overseas, when they get into trouble with the local authorities, what we typically do is we will hire a local lawyer to defend them. One of the reasons that we do that is because there may be a conflict between the government lawyer's role as a government lawyer and the role of the lawyer there to represent the individual in a local proceeding. We do provide trial observers to make sure that the treaties we have with these countries are adhered to in terms of due process. But in this particular case, what we did was because the central issue was a difference of opinion on what international law was and what international law said, particularly who had jurisdiction over Colonel Romano under the NATO Status of Forces Agreement. We government lawyers basically represented Colonel Romano in the criminal proceedings. We obviously associated folks who had the ability to appear before an Italian court, but we ultimately represented Colonel Romano to represent the U.S. government's interest in his individual criminal prosecution. That's not always the case, where Colonel Romano's interest in maintaining his liberty is congruent with the U.S. government interest in defending its treaty prerogatives. In this case, fortunately, they both were consistent. But it's an illustration of how the rules of professional responsibility played a part in determining whether or not we could actually participate in the defense of a military member who is subject to the authority of a foreign government. The landmine treaty. In modern warfare, we as judge advocates may, on occasion, be asked to advise commanders who are not American. Certainly in Iraq and Afghanistan, that's the case. In NATO operations, it's the case whenever we have coalition operations with any other country. And our obligations will depend upon whether or not our interests are aligned with the interests of the country the commander represents. The landmine treaty is a good example of a case where most of our NATO allies, if not all of our NATO allies, are signatories to the Landmine Convention. The United States is not. And so in a coalition context, if the commander does or doesn't want to use landmines, should a U.S. judge advocate advise on those issues, knowing that the law that we're responsible for enforcing and advising is inconsistent with the commander's desires. We feel strongly enough about those issues that we normally apply a bring your own JAG approach to coalition operations. It's a great way to meet allied judge advocates, but it's also an opportunity for commanders to be able to rely on their lawyer consistent with their obligations of professional responsibility. And they are secure in the knowledge that the advice they're getting is consistent with their view of whatever the law is that applies to the situation. Conflict between agencies of the U.S. government. Remember, I started this discussion by talking about what our Air Force rule is. Our client is the Air Force. It's not the federal government. It's not an individual unless we have authority to advise either of those clients. And so we as JAGs can't even advise the federal government unless we're given authority to do so. One area where we are given that authority is in the context of enforcing the exclusive jurisdiction of our military installations. We will routinely get our young judge advocates deputized, if you will, as special assistant U.S. attorneys, who then become responsible for representing the Air Force in federal court, usually a magistrate court, in situations involving the violation of federal law on the installation. A recent case, recent as Wednesday, the case of US v. APEL, A-P-E-L, decided 9-0 by the Supreme Court, overturning a Ninth Circuit opinion, which I always like, was basically started by judge advocates in magistrate court trying to prosecute a gentleman who unlawfully protested on Vandenberg Air Force Base in California. So it's an example of how we can represent the government. But these cases here that I've mentioned, Guantanamo, torture memo, those are cases in which the Air Force's or the military's interests did not necessarily align with the interests of the rest of the government. We had some discussion about the U memo here earlier, and clearly what that memo purported to allow us to do was inconsistent with our obligations as military members to care for those folks who are in our custody, not mistreat them. Our Geneva Convention obligations not to torture. And so as a result of the national debate that ensued after that memo was released, the Air Force lawyers actually took positions opposed to the government. It's one of the reasons why the Judge Advocates General have 3 stars nowadays. It's fact. So those are situations where, again, our professional responsibility rules drive us or enable us to take positions that are in support of our client and perhaps contrary to the larger government. And then lastly, I want to stress that it really doesn't matter whether it's policy or law. Most lawyers are only engaged in matters of law, advising their commanders of law or advising their clients of law. We have a much larger portfolio, a much larger body to be concerned about. And so I close with that to acknowledge that, those of you who are in law school who want to pursue a career in government service or the military, your horizons will expand considerably when you leave this institution. You'll be asked to do some things that no one here prepared you for. You'll be asked to not only maintain the rules of professional responsibility relevant to whatever state licensed you, but you'll also be responsible for the specific rules that in some cases go above and beyond that the military or whatever government agency you're part of requires of you. So I, again, appreciate the opportunity to be here. Happy to take any questions. I think we have like 3 minutes that we have to occupy so we can all get CLE. Yeah.
Sir, hey, Butch Bracknell, you were sitting right here next to me.
I was.
Know each other. You mentioned this national security exception for the rule of confidentiality. How often is that tested? How do the state bars view that? I don't know of an analog under the model rules that I can think of. So that's kind of a unique. I don't even know that it's in the. I've never heard of that one in the Navy rules anyway, so that I practice under. So can you talk to that one about whether that's been tested against a state bar?
I don't know. I don't know of a case in which it has been tested. I do know that it is consistent with our obligation, as I said before, to report violations of the law of war. You know, there are probably lots of other contexts that we haven't even thought about where what were perhaps considered confidences have been revealed in order to avoid some kind of national security disaster. To my knowledge, no one has ever disputed that. No one, in my knowledge, has ever taken it to a state bar. You know, as the judge advocates general of each of the services are responsible for the professional responsibility rules, and when they are violated, they have an obligation to not only take action with respect to the certification or the designation of the person as a judge advocate, but also to report these problems to the state bar.
Can I come in on that?
Yes, sir.
Under your state ethics, you generally are not protected with confidentiality where there is an ongoing crime or fraud upon the court. An analog to that duty under your state bar, there is an exception that you can breach the client confidentiality to prevent the commission of a crime or a fraud upon the court. So where you have something that is an ongoing crime, you're not confidential on that. So I think there is an analog in other lawyers' practice.
If I could jump in here, Steve, along that line, I think where it comes up in that I can think of is in connection with the personnel reliability program in the nuclear context. And people engaging in behaviors that, you know, might raise the question of their reliability in that particular unique context, but I'm not aware of it ever being tested. And I do want to make, just help my friend Steve here, because this is going to be on video, about General Mosley. It's a very complicated situation. And I want you to know that General Mosley was not a contracting authority. He didn't have the authority to give, he didn't give anybody a contract. He didn't have that kind of authority. And in fact, the IG never found that there was any impropriety along that line. There was some criticism about the appearance because he, you know, accepted a CD that somebody made of his daughter flying and so forth, who was seeking a contract. So I don't want you to walk away with a misunderstanding of that about General Mosley, but I think it does highlight the sheer complexity of these situations. And Steve, I think one of the things that we've seen is when you're advising these senior leaders at the 4-star level, it is unbelievable the variety of pressures that they come under. They are very different kinds of clients than what you see in other contexts. And they have conflicting responsibilities, and I think that they really do. And one of the things that Steve said that really resonates with me is that, you know, he said commanders do make a lot of jokes about lawyers, but they really do value. And the more senior you get, the more time you spend in a senior officer's office. And the interesting thing that I found, and Steve, I'd be interested to hear your reflections, is that they often, I would say at least 50%, 60% of the time that I was called in to senior commander's office in my last few years of practice, it really wasn't a legal issue, honestly. What they are trying to tap into is what Steve talked about earlier, the candor that they get from lawyers. Because the fundamental instinct in the military is a can-do attitude. They're going to do what the commander wants done. Lawyers we're in the business of telling people what they need to hear versus what they want to hear. And commanders recognize, sort of instinctively, that lawyers think a little bit differently. You know, when you go to law school and you study evidence, you don't read the newspaper the same way, because you're constantly evaluating data. They like the way lawyers break down problems into elements because you took crim law. And they like the way that lawyers will distinguish between what the law provides and what is their perspective. And so these basic lawyer skills that I'm speaking a lot to our young law students, that you learn will be used in maybe a different way, maybe not so much in interpreting the law, but in helping the client. That's that Rule 2.1, the lawyer is a counselor, that you're going to find, especially in the national security realm, which becomes so important. Steve, was that your experience?
Yeah, absolutely. Absolutely.
Well, with that, I think we've hit our mark here. And Steve, that was... It did take us 4 years, but I'm so glad that we got you back on the schedule. A couple of things before we close up shop here. For those of you who are looking for CLE, especially in North Carolina, as soon as we get that in, we have your emails if you've signed up, and we will send you that approval. In addition, everyone who signed up for CLE will get a copy of a brilliant law review article on the ethical issues of national security law. Ooh, who wrote that? Oh, that's me. That's right. And a lot of people have asked about the video. Yes, everything except Mr. Preston's dinner speech has been recorded and will be posted. We don't want to live cast. I don't want to live cast this conference because I want to have a premium so you all hear it first. And I also want you to come so that we can interface with each other, because that is still, in our era of teleconferencing and everything else, it is still so important to interface. And along that line, I want to give a special thanks to our judges. You know, we had 5 federal judges who stayed here pretty much through our whole conference. And not only am I in the law school personally honored by it, but I think it sends just such a great message to the young people who have come here. It really, judges really appreciate it. It makes a huge difference. And I also want to extend a special thanks to our non-lawyer attendees, and especially Ollie, Campus Club, the Farrington Village Gang. Is that the right word to use for Farrington Village folks? And as well as, you know, my friends, the Kilpatricks, because you add another perspective that I think is so important, and Phil Carter kind of alluded to this morning. It facilitates that interface between the national security realm and the general public, and it helps a lot that to have you come and then go out in your communities and help to educate people as to what really the law is and what the facts are, which so often get lost. I want you, and please mark your calendars for next year. It's February 27th and 28th. I can't officially, is this being recorded? Because in the Duke University rules, you can't actually say it's going to happen, but I'm a general. I usually say whatever the hell I want to say, so our target is February 27th and 28th, and I guarantee you, everyone who is registered for this conference will get the notice first. As you know, it books up pretty quickly, and I really do hope to see you next year. And with that, I do want to invite you again to seriously to give me some feedback on what we can do better next year. You will get a survey, and I hope that you take some time to fill that out. And really, I just want to thank everyone for participating, and especially you know, our distinguished speakers, but also everyone here, because it really does make a difference that, you know, this community, the people interested in it, it's larger, it is growing, but it also is intimate. And in so many ways, in so many places, when I was practicing national security law, the fact that you knew somebody, it really does make a difference. The fact that you have these personal connections. And so I applaud our students and others who have taken this opportunity to network. You know, that somehow has, in some people's mind, a bad connection. Only a good connection in my mind, because it is so important. But really, this conference, I am really thrilled with it, but it's mainly because of you all. The questions, the discussions that you had during the breaks and at the dinner last night, it really means a lot. Thank you so much. Hope to see you next year.